There's no legal definition for a digital asset, but in basic terms, it describes assets or information stored on the internet. So that will include things like Twitter, Facebook, Instagram, email accounts, those sorts of things. There's no standard practice as to who owns the digital asset, as all service providers have their own standard terms and conditions. So it's going to be dependent on those, and those can't be varied or negotiated with the service provider. They also tend to be quite lengthy, so Apple's terms and conditions are around about 21,500 words, so it's not practical for users to read those before entering into the agreement. But in general terms, the user owns the content and the service provider has a license over it. Probably the most famous exception to the rule is iTunes, because in that situation you don't own the music, you only have a license to listen to it. So when you die, you can't leave your music library to your beneficiaries, and so the asset in effect dies with you. There's been huge advances in technology even in the last 10 years, and this is a relatively new concept for most people. They don't think about what will happen to their online content when they die. In some cases, those digital assets have a monetary value, so it could be that there's online photographs or books or poetry that have value, and those can be left to beneficiaries under the terms of their will. In other cases, in most cases, it is just sentimental value, and those can be left to beneficiaries as well. They just need to be referred to specifically in the will, so it just needs to be dealt with in the right way, referring to the intangible digital asset in the will itself. The best way to protect your digital assets in the first instance is to make your executors aware of what assets you have out there. Then you've got the debate as to whether you should also leave usernames and passwords with your executors. Obviously there's a security risk of writing your usernames and passwords down. One solution to that could be to leave that list of usernames and passwords with your will. So in summary, you need to be aware of what would happen to those digital assets when you die. Plan ahead so that you make sure that those assets aren't locked or destroyed if you die, and have a strategy in place with your executors or your solicitors to make sure that they're dealt with in the right way.